What's up, everybody? And welcome in here to some more Kohberger talk. And if you're down to hang for the next couple hours, you've come to the right place. As you know, I don't usually do the long streams. And while this live is not going to go for hours, it is an interesting day here on the channel because over the last couple days, I was recording the reaction and live watch of the Brian Kohberger hearing where the media argued against the gag. Actually, don't call it a gag order, as the judge said, non-dissemination order, arguing against it. We heard from the defense. We heard from some of their experts as to why this non-dissemination order needs to stay. So over the last couple of days, I think it's over 2 hours is that stream. And that is going to play directly after this. It is a redirect. And a lot of that I recorded from home at night. So you guys will be able to watch that directly after this. And although it's been a few days, I was thinking as I was recording it, like, man, is this already stale? Are people going to care? People kept asking and pushing it. I couldn't find it at first because it was just on the Court TV website. So I did end up finding it. And here's what's really interesting. As we read through today's documents, the replies and the motions and the briefs, it actually becomes very relevant because one of the main things the defense is hanging its hat on and talking about, even in these grand jury arguments and about the indictment and what the problems with this case could be, a lot of it centers around the media. And one of the big questions is, how are they going to be able to prove that? And I think that hearing and those experts become relevant yet again, because I think the defense, we're going to hear a lot of that throughout this case. So much media attention, so difficult because it's all negative and it's potentially prejudicing a potential jury pool, or maybe it has already prejudiced the grand jury, grand jurors. So we're going to get into that today. We're going to read the defense's reply. We're going to read their motion to stay. What are they asking for? Do they give us an indication about how they're going to fight this grand jury indictment? Does standing silent matter? We're going to talk about all that and more on today's video. So hit that like button if you haven't already. Subscribe to our page. I'm going to bring in my dad to talk about this potential grand jury indictment challenge. Hello.
Hello.
So you've had a chance to read through these documents. We're going to read through them together with the chat today. But before we get to it, what are some of the main challenges that attorneys have to grand jury indictments in situations like this?
Well, they take two forms. One, you attack the grand jury itself, its makeup, who's in there, prejudice and bias in the grand jury. The other is prosecutorial misconduct in the grand jury, where the prosecutors, because remember, there's no defense lawyer, there's no judge, it's just the prosecutor and the grand jurors. So if you don't have an ethical prosecutor in there, there's all sorts of available abuses that a prosecutor can do. So it takes those two forms, either the grand jury itself, its makeup, or the prosecutor doing something wrong in the grand jury.
Right. So when you say prosecutorial misconduct, you're saying prosecutors saying, oh, there's a confession when there wasn't, or using a piece of evidence they know is fraudulent or planted, or doing something that they know is wrong, or committing fraud on the court, basically.
Right. Giving them bad legal advice, because the prosecutor is the lawyer for the grand jury. So they rely on that prosecutor to say, all right, what is the law and how does this crime comport with the law? And so the wrong law obviously comes out with a wrong decision from the grand jury.
Right. And when you're talking about the makeup of the grand jury, you mean, are those the people that are supposed to be on this grand jury, or was there something obvious that disqualified them from sitting on this grand jury, including some of the case law that was cited here where somebody made it onto the grand jury inappropriately? Why don't you tell that kind of example of another issue with the grand jury?
Right. Well, in the pleading, the motion, they have a situation where they cite this case, I think it's called Roberts. And in that case, a grand juror didn't show up one day. So the sheriff went out and grabbed somebody randomly and put them in the grand juror as a grand juror. Well, that person wasn't properly qualified to be a grand juror, so they stuck him in there. So he, number one, we have a grand juror who isn't supposed to be a grand juror, not properly qualified. Number two, we have somebody in the grand jury room that is not sworn to secrecy according to the statute. So we have all sorts of problems, and we have them voting on an indictment when they shouldn't be voting on the indictment. So in that particular case, they did throw out the indictment.
Right, exactly. And that kind of gives an example of where we have to get to in the very difficult task of challenging a grand jury indictment and winning. CH asked, does the time delay in paneling a grand jury come into play? No, because it was done within the timeline it had to be done in order for the grand jury proceedings to take place. So that's not going to be an issue. Okay, so let's get to the actual documents here. And I actually forgot to mention, because I saw some people saying I'm pausing the Scott Peterson trial or pausing the Melly trial. Emily Baker, I guess, is streaming right now. Somebody said in the chat. So I know there's lots of places to be. So thanks for being here. And of course, if you watch it later, that's cool as well. But we don't only have this video and then a couple hours of a Brian Kohberger hearing. But after the office closes today, after 5 o'clock, I will be doing a YNW Melly trial update. And I think tomorrow I'm going to do Scott Peterson. So a lot more to come, a lot more time to hang out today and the rest of this week for those of you who would like to. All right, let's get to the defense's reply here. All right. Defense's reply filed on June 13th to the state's supplemental response to defendant's motions regarding the grand jury record and transcript. Comes now, Brian Kohberger, buying through his attorney Ann Taylor, public defender, and replies to the state's supplemental response to the defendant's motions regarding grand jury record and transcript. The state argues that Mr. Kohberger is only entitled to an audio recording and or a transcript of the grand jury proceedings and the grand juror notes, but not other enumerated items set forth in Idaho Criminal Rule 6. The state also objects to a qualified protective order, preferring instead to keep requested materials protected by adherence to the word sealed. Release of the grand jury proceedings governed by rule and statute are materials necessary to Mr. Kohberger's defense. Article 1, Section 8 of the Idaho Constitution, Idaho Criminal Rule 6, Idaho Codes 19, all these different sections provide authority for release to Mr. Kohberger. Good cause is not required, but exists to release all items into Mr. Kohberger's motion as set forth below. So, just to start out, whoops, I don't know how I did that. There we go. So just to start out, they're basically saying the state only wants to give a recording. They don't want to give other things that are enumerated in the rule. Defense wants things that are enumerated in the rule. They don't have to show good cause, but they will here, right? So that's kind of the basic of as we jump in, that's what the defense is saying. And as we read this, well, I'll save that. Okay. So, procedural background. Mr. Kohberger was indicted by grand jury on May 16, 2023. He filed a motion to make available the record of all proceedings of the grand jury pursuant to these rules. On May 19th, the state then filed their state's response to defendant's motion and proposed order. We're going to look at that proposed order later to talk about what the state has basically agreed to or what the state would like to do in this situation and what they would like to give over based on or in comparison to what the defense wants. The parties were not able to reach an agreement regarding the release of grand jury materials, which resulted in the state filing their supplemental response to defendant's motion regarding grand jury record and transcript on June 6th. The defense's reply follows. So the state basically proposed an order that the judge could have signed saying, here's what we think. Defense wants more. Secondary argument is whether we're going to use a qualified protective order or the word sealed. That'll be kind of at the end of the motion. So first, Mr. Kohberger has a legal right to challenge the grand jury indictment, and the court should release all records requested in his motions. So, Dad, let's take a second here. Kohberger has the right to challenge these grand jury proceedings. Nobody is arguing with that at this point. But do you see anything in any of the research that you've done, any of the motions that we've read? I know the defense says that's the reason he stood silent, and I know he says it in the hearing we're about to watch later. Again, if you want to hear it actually from the horse's mouth, the defense attorney saying the reason Brian Kohberger stood silent is to protect their right to challenge this grand jury indictment and not agree with the validity of it. Do you see anything that says if you plead not guilty that you couldn't also preserve that right?
No, I really don't. And keep in mind, even though he didn't say anything, the judge still entered a plea for him, and the case went on just like it would normally do. There was an arraignment. That was a legal arraignment, whether he said anything or not.
Procedurally speaking, standing silent is the same thing as pleading not guilty. And if he was worried about protecting his right to challenge the validity of the grand jury indictment, all his lawyer would have had to say is, Judge, without waiving any right to challenge the grand jury indictment, and then Brian Kohberger could have pled not guilty, or the attorney could have pled not guilty on his behalf. It does not matter, in my opinion, right? Now, standing silent, he is correct. It also does preserve that right. But I don't think it's the only way to preserve that right. And I do think it is still an intentional decision. That's just kind of my thoughts on it. All right. Mr. Kohberger faces charges of 4 counts of first-degree M and 1 count of burglary. Because the first-degree M charges, the state can file notice of intent to seek the death penalty. After Mr. Kohberger's early January court appearance, counsel for Mr. Kohberger and the state planned for a preliminary hearing scheduled for the week of June 26, 2023. A preliminary, it's crazy to think that that still is not here yet, and all this has happened. A preliminary hearing would have allowed the defense to challenge evidence the state claims to have against Mr. Kohberger. The state, as its option, chose to proceed with a secret grand jury. So just to be clear, although the defense is arguing they would have had the opportunity to cross-examine these witnesses and potentially put on evidence and show their theory of the case, that is not an ultimate right of the defendant. The state does have the option to do it this way. There was nothing improper about the state going the grand jury route. That's what they decided to do, and that's fine. The defense is just explaining how we got here. A grand jury was impaneled at a time when the small community of Moscow, Idaho, had been exposed to 6 months of intense local, national, and international media coverage. More on that later. If you're really interested on what their expert has to say, the hearing right after this video that we watch explains that more. Because the state has provided extensive discovery, Mr. Kohberger knows that exculpatory evidence exists. So what do you think about that, Dad? Their first argument is big time media attention, and he knows exculpatory evidence exists. Can we say at this point the defense is confirming they believe they have evidence that proves his innocence?
Oh, I'm sure they think they have evidence that proves his innocence.
So them saying something like that is not the same thing as there is potentially exculpatory evidence in the grand jury proceeding, or there is potentially exculpatory evidence somewhere else. They are saying at this point, we believe that we have exculpatory evidence.
Right. And it wasn't presented at the grand jury. I think that's what they're trying to infer.
Right. And they are going to try to challenge the grand jury proceedings based on the fact that the prosecutor did not let the grand jury know that exculpatory evidence exists.
I mean, honestly, I don't necessarily think that the prosecutor has to let them know that. If the jury wants to see other evidence, they have a right to ask for it, but there is no necessity for it.
And I think that there is. I think that
we disagree on that.
Right. And I think it is nuanced. I don't think the state has to necessarily present it a way that the defense attorney would present it, but I think there are certain things that could be considered prosecutorial misconduct if they hide certain evidence or don't present certain evidence to the grand jury. Are you going to say something, or are you?
No. There's an Idaho code, and I was going to get that for you, but go ahead.
Okay. So, but this is something the defense is planning on challenging. The first things they bring up is exculpatory evidence that they believe exists, that they don't think the grand jury knows about. And number 2, the media attention that this case got for 6 months. Okay. So those are the first 2 kind of swings that the defense is taking. Whether a fair and impartial panel of grand jurors was assembled amidst intense media coverage is a significant question the defense must evaluate. So they want to see exactly what you said before, Dad. The way this grand jury was impaneled and the people that ended up on that grand jury is incredibly important, especially amidst all of the media attention. And that's the Roberts case, I think, that you were talking about.
Well, Roberts is the case they cite for the authority, but Roberts was not a high publicity disqualification.
Right. It's the sheriff case.
Right.
Right. That's interesting. So it doesn't really have anything to do with media attention.
And they did cite a case that did.
Say that again.
They did not cite a case that did have something to do with media attention and the grand jury.
So they didn't have any of those.
Right.
Whether inadmissible or exculpatory evidence was presented to the grand jury is a significant question the defense must evaluate. And while there are many other legal arguments Mr. Kohberger may pursue related to the grand jury proceedings, how the grand jury was selected and what evidence was presented illustrate good cause for the defense's need for all materials set forth in its motion. So I think this is important to pause here and bring up the state's what the state kind of agreed to in their state's response. So this was the proposed order. So the state agreed basically that they would turn over a transcript of the proceedings herein, except deliberations, so not the jury deliberations, will be prepared as contemplated by the rule. A copy of the transcript and record will be provided to the state and the defense with the understanding that the same will remain confidential. So the state is seemingly agreeing to provide a transcript and record, but the defense is arguing that that's not good enough and they need more, right?
Well, what the state is quoting in that section is the rule 6.2, which specifically says what it is that they have to turn over to the defense. And you'll get to later about, I know, what other disagreements they're having. But as far as them agreeing to the record from the grand jury, that is definitely what the rule specifically says that they have to do.
Go ahead.
Well, again, it's the same. You talked about the preliminary hearing versus the grand jury. They'd be entitled to the preliminary hearing transcript as well. So it's identical to whether it's a preliminary hearing or a grand jury. They're entitled to the record that was made in that grand jury.
Which is a little bit different, obviously, because they were there, so they would know.
Right, preliminary hearing, they'd be there, right?
But as we'll see as we get through the defense's motion, they're worried about not knowing what they don't know because they weren't there, so they won't be able to tell if certain portions are missing.
Yeah, right. And restrictions.
Right. So again, we're back to the defense's motion now. After seeing what the state agreed to, seems kind of strange that the defense is still seemingly arguing that Mr. Kohberger may pursue related issues with the grand jury proceedings, how they were seated, and what evidence was presented. That you would think would be contained within what the state has agreed to turn over already, right?
No.
Why not?
How they were seated, how they were selected, how they were drawn from the juror pool, that's not part of the proceedings.
Right.
So they would not be getting that.
Right. But the questions they were asked while they were being selected and things like that would be part of the record.
I do not think so.
Really? In a normal trial, it is.
Right, but not in a grand jury.
Okay. All right. So there are additional things outside of what the state has agreed to.
Yes.
Right? Okay.
Yes.
All right. Mr. Kohberger is entitled to pursue relief on a single error or cumulative errors. Why don't you explain real quick the difference between a single error and cumulative errors? I think it's kind of self-explanatory, but go ahead.
Well, sometimes there's like one big mistake that is enough to show that this person didn't get a fair shake in the grand jury, or that one big mistake isn't there, but you've got 5 or 6 little mistakes. And if you put all the little mistakes together, then you're going to have a situation where it's an unfair grand jury, and therefore it's tainted, and therefore the indictment is tainted and should be thrown out.
And I think that that's the other really important part about why they need everything, because it may not be one thing was big enough to say that this was not a fair grand jury, but if they get a ton of things and problems all over the place, then it may be enough. And that's why you never want to be married to just one single error, right? If you can have cumulative errors, that's always better for the defense to challenge something. All right. To determine if there are cumulative errors, good cause exists to review all items requested in his motion. Cumulative error exists when the cumulative effect of the errors and indiscretions, none of which alone might have been enough to tip the scale, operate to the defendant's prejudice by producing a biased grand jury. Pursuant to Idaho Criminal Rule 48, Idaho Code, this, that, and the other, Mr. Kohberger is entitled to request the proceedings be stayed while he challenges the indictment. They file a motion to stay. You want to say something about that?
Yeah, well, I want to go back for one step. They cite this case, Simango.
Yeah.
U.S. versus Simango.
Yeah.
And that talked about a fair trial. So understand that what they're using for authority here are trial jurors, not grand jury proceedings.
But there
so
are
couldn't find a case for the grand jury.
Right. But there are there are a lot of similarities. I think that they can use that argument appropriately, but you better believe the state's going to differentiate with that there is
Right.
a very different process than the grand jury. But the truth is, how many grand jury cases are really reported that we can use as precedent in cases like this?
Right. Well,
Not
I've
very
done,
many, right?
and they don't get reversed. Grand jurors,
Exactly.
it doesn't happen.
And they don't get reversed. They don't get appealed. We don't have a lot of appellate courts making
Right.
decisions. And that's the other thing. I mean, we could do a whole video on how stuff becomes precedent and how it has to go through certain levels. And just because there is a grand jury that happens in some other state or even in Idaho, it doesn't mean you can use what happens in that grand jury as precedent in another case, because usually you don't even know what happens and nobody ever sees what happens. Nobody ever sees the challenge because it's all sealed or under protective order, right?
Right. Well, I've done hundreds of grand juries, state and federal. When I was a prosecutor, state prosecutor, federal prosecutor, they never had a successful challenge.
Ever, right? I mean, although to be fair, in all of your years as prosecutor, how many cases did you lose on appeal?
Very small percentage.
That's what I'm saying. Even that is a very small number. Grand jury losses on appeal or being thrown out for a bad grand jury indictment is minuscule, literally minuscule. So not a lot of case law on it. Okay, the rules provide for the release of all enumerated items in Mr. Kohberger's motion without good cause, meaning when it says without good cause, it just means he doesn't even have to prove good cause. They just are, you have to give them over, regardless. You're shaking your head.
I don't see where his authority is for that. I've read 6.2 and 6.3 of the Idaho Code, and I don't see his authority that whatever he wants, he should get. The district court has the authority to give him almost everything he wants, but not just because he's asking for it. There's got to be some reason.
The way I read this is he is saying there are certain parts of the statute that say with good cause shown. And this is not part of the statute that says with good cause shown. So if it is enumerated in the statute or in the rule, then you have to turn it over. That's the argument that they're making. I don't think anywhere in the rule it would say without good cause shown, you get this, that, or the other. But you know how certain statutes say with good cause shown, this is not one of those. Therefore, if it's enumerated in the statute, he gets it regardless of if he can show good cause. That's how I read it, at least. All right. He's requesting the items listed in Idaho Criminal Rule 6 and 19. Each portion of the grand jury he is not seeking anything outside of the rule or statute. So everything he is requesting is within the rule and statute. You're saying you don't agree with that?
I don't.
Okay.
I'm reading it, and I could quote it. And it says that the district judge by motion must permit the following persons to listen to the record of the proceedings of the grand jury or obtain a transcript of the proceedings in the same manner as a transcript of a preliminary hearing. So that is a record of the proceedings. They've asked for a lot more than a record of the proceedings in their motion.
Okay, I have not read Idaho Rule Criminal 6 in its entirety, or 19, 1001, 2021, 1201, and 1401. Maybe I will read it before the next video. You read all of those, you're saying?
Yes.
And none of them list. Well, I guess, is that going to be the argument then, is whether the jury impaneling is part of the record or not?
Well, that may be part of the argument, but the point is they haven't even gotten the record yet, so they don't know what's contained in that record yet. They haven't even gotten it.
It seems like they know it's not, right? I mean,
and I would presume, to be honest with you, that it's not.
Right. And I mean, I would think if they talked to the state and the state said, yeah, all that's in there, we'll get it all to you, then they'd be fine. But I don't think that's what the state is saying.
I don't think it's all in there. Everything they've asked for, I don't think is in there.
All right. Each portion of the grand jury proceeding is specified in his original motion and in the rule. See motion to make available the record of all proceeding. The state's suggestions that he should listen to the audio recordings and or review a transcript of incomplete proceeding merely adds delay to Mr. Kohberger's ability to challenge the grand jury indictment. So that's another question. What is the state's definition here of incomplete proceeding?
Well, I mean, we don't know. This is all speculation. I mean, when you read this, the defense is just speculating that this is not included or what is or isn't included. there's no reason why they shouldn't go ahead, get this stuff, and then file another motion and make their argument. Or ask the judge to take a look at it, what we call in camera. In other words, the defense and the prosecution don't get to see everything. Obviously, the prosecution knows it all because they did the grand jury. But the judge can take a look at it and decide if there's anything in there the defense needs or the defense could use. But they have that option. But until they actually see what they're going to get, this seems like it's premature.
So I disagree that this is all speculation. I would bet a lot of money the defense knows exactly what the prosecution was going to turn over and what they were not going to turn over. And that's the point of why they didn't agree. And the prosecution agrees that they didn't agree. And therefore, the judge is going to have to determine what they're going to turn over. That's how I kind of read this. But I don't think they're just guessing, not knowing what's in the record that's going to be turned over to them. Okay. Essentially, Mr. Kohberger is asked to look at some, but not all, and then ask for more at a later time. Would you agree, if that is the case, Dad, would you agree that that is not fair?
Why wouldn't it be fair if he's allowed to come back and ask for more once he takes a look at this and finds out it's not in there? I don't think, I think it's fair.
Okay, so sorry, are you done?
No,
everybody says I interrupt you every time we do a video. Let me sometimes drag on. So I try to keep it moving quick. I'm not trying to cut you off, obviously. And I don't think you would let me cut you off. If you had something to say, I'm sure you would say it, just so everybody in the chat knows. Because I literally get that every time we do a video together, just because I try to keep it moving as quick as I can, because we got to be done by 2:45. Okay, so what I mean by that is some but not all of the record. If we agree he has to get the entire record, then he should get the entire record, right? Not some but not all of the record.
Well, but then again, you're defining the word record.
Well, I'm saying, let's just say that the state's going to only give some of what they define as the record. You think that would be unfair?
If it's not all of it, yes.
Okay. And the only reason I also think it'd be unfair is it is a waste of time. And here we go. Here's kind of the argument I was going to make. Mr. Kohberger's right of a speedy trial has not been waived. This sort of a delay would require either a waiver of his important right to speedy trial or for counsel to represent him less than fully prepared. As such, Mr. Kohberger, under separate but contemporaneous filing, is requesting that his case be stayed during the now contested process obtaining materials he must examine. So that motion to stay is not just to stay what's going on, but also to stay the tolling of his speedy trial time, right? That's what's so important of the stay and the pause in the case, similar to Lori Vallow, that they had to stop that case because of her competency issues, right?
Right.
Okay, authority for the stay is contained in Idaho Code 2213. A party may move to stay the proceedings and in a criminal case to quash the indictment or for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand jury or trial jury. And again, this is kind of similar to just an interlocutory appeal sometimes, where you stop the case because something incredibly important has to be decided by the judge before we can continue the timing of the case. That speedy trial time is just enough time to prepare for trial. It's not enough time to fight the grand jury indictment and prepare for trial at the same time. Mr. Kohberger is acting with diligence to discover grounds upon which to challenge the indictment through a motion to dismiss. The state's obstruction of release of the full grand jury proceedings is creating unnecessary delay. This case should be stayed until Mr. Kohberger has complete access to all matters related to the grand jury proceedings and until such time as he can file an Idaho Rule 48 motion to dismiss the indictment. Or, as Mr. Kohberger is requesting, the court should order all grand jury records released so that the defense work can be done. The state's reliance on State v. Abdullah for the standard that good cause is required is not accurate. Mr. Abdullah's grand jury proceedings were in 2014 before Idaho Criminal Rule 6.2 was adopted in 2017. The rule does not require good cause, and even if it did, good cause exists as explained earlier. So once again, they're saying we don't need good cause, but if we did, we've got it. And it seems like this case changed that. I didn't read this case. The rule does not require good cause, and even if it did, good cause, sorry, I already read that. In Mr. Abdullah's post-conviction case, he was arguing that the grand jury transcripts that had not been included in the appellate record needed to be added and briefed as a subsequent issue. Mr. Abdullah wanted to argue that the grand jury term had expired. In this case, Mr. Kohberger is asking for grand jury records immediately following his indictment and before the jury trial, not years later in a post-conviction proceeding. Very different case, obviously. It is worth noting that Abdullah illustrates how issues such as this have plagued cases in the appellate realm for decades. Release of grand jury records now allows Mr. Kohberger's defense to provide effective representation. Go ahead.
So he is correct when he says 6.2 does not require good cause, but he is interpreting 6.2 a lot broader than I would or than the state is. So that's a judge is going to have to determine that, because 6.2 only talks about a record of the proceedings. That's it.
Okay. Sealed versus qualified protective order. Mr. Kohberger seeks access to these records, whether sealed or under qualified protective order. Defense counsel needs to be able to disclose the grand jury records to the defense team, including relevant experts, with the admonition that the records are not to be copied or dispersed. We agree with this, right?
Yes. And the judge is going to allow that.
Right. Whatever he gets, you got to share with defense team so they can represent him.
Right.
Defense counsel needs to be able to review the records with Mr. Kohberger, but does not seek an order to provide him with a copy. Additionally, the defense needs to be able to refer to the records in legal challenges or witness examination. To protect the sensitive nature of the records and pleadings referencing grand jury proceedings, any such pleading can be submitted to the court with a motion to seal. Conclusion. Mr. Kohberger is entitled to review all grand jury proceedings as set forth in his original motion to make available the record of all proceedings of the grand jury pursuant to ICR 6.2 filed May 19, 2023. Although good cause is not required, it exists because the grand jury was impaneled after 6 months of intense media coverage in a small community. Exculpatory evidence exists, and there may be a single error or cumulative errors which require the examination of the entire grand jury record. If you want to know what this motion is about, this sentence right here summarizes it. Impaneling a jury after 6 months of intense media scrutiny in a small community, exculpatory evidence exists, and there may be a single error or cumulative error, so we need the entire grand jury proceedings. That is the summation of this motion. He does not object to the records being sealed, as clarified earlier. He agrees with the state that the grand jurors' notes should be included in the records provided. Again, that's referencing back to that proposed order. Should the court release only partial records or transcripts, Mr. Kohberger requests a stay of all proceedings pursuant to Idaho Code 2213 until such time as he is able to review, request additional records, provide a sworn statement of reasons, and file ICR 48 motion to dismiss. So ending there with that motion to dismiss, there's actually two things I want to hit here. Number one is, so basically the defense is giving some alternatives to this judge. Number one, judge, if you don't give us everything we're asking for and we have to do the piece by piece deal where we watch it and then we ask for more and it's going to cause all these delays, then give us a stay. Would you agree that's one option they're kind of throwing out there?
Yes.
But if you're not going to give us a stay, then you have to give us everything. Because if you don't give us everything and you don't give us a stay, now you're violating his speedy trial rights, his right to competent counsel. And so they're kind of putting that pressure on the judge to make a call kind of between those two.
Well, the judge has the duty to protect the constitutional rights of the defendant. And if the defendant cannot adequately prepare for trial based on the time limits you've got because of these actions, then certainly you've got to stay it because you've got to give him a fair trial.
Right. And I think the judge has made that absolutely clear that that's one of the first and foremost things in his mind. Remind me, Dad, if I don't forget, I want to do this motion to stay proceedings, but then I also want to talk about what happens when they file this motion to dismiss and how that kind of goes. So motion to stay proceedings real quick here. Procedural background, he was indicted. They filed all these motions. The parties are not able to reach an agreement regarding the release of grand jury materials. In further opposition of Mr. Kohberger's motion for the preparation of grand jury records, on June 6th, the state filed their state's supplemental response to defense motion regarding grand jury record and transcript. A hearing is scheduled for June 26th. So that's when we're going to hear this argument. Hopefully there are cameras in the courtroom to argue this contested matter. Mr. Kohberger stood silent. And here's where the defense attorney, he said it in the hearing you're about to hear, but also he says it here, stood silent at his initial arraignment to preserve his right to contest the indictment. He also asserted his right to a speedy trial pursuant to the United States and Idaho constitutions. Jury trial is scheduled to begin October 2nd, 2023. Time is of the essence. Argument. By the time this court hears argument on the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of the indictment. Preparation of the grand jury record will then take additional time. Mr. Kohberger has a right and intends to contest the indictment. Idaho Code 213 allows the defense to seek a stay of proceedings within 7 days after the moving party discovers or by the existence of due diligence could have discovered the grounds thereof, and in any event before the trial jury is sworn to try the case, a party may move to stay proceedings, and in a criminal case to quash the indictment or for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting grand or trial jury. Again, that's why I think there is some connection there with some trial court juries and some of the research that was being done. Mr. Kohberger seeks to stay the proceedings as appropriate relief while the matter of the grand jury record is argued and prepared. He is exercising due diligence to discover the grounds upon which to file the motion to dismiss related to how the grand jury was selected. He is being delayed by no fault of his own. So again, he has a duty to, as quickly as he possibly can, find the errors and then file the motion to dismiss. You can't just wait for years like that other case. But if he can find the errors, whether it's with the media, with the exculpatory evidence, whatever it may be, he needs to find them now and file that motion now. That's what they're saying there, right?
Right. And
go ahead.
Going back to 6.2, we're talking about the grand jury and the judge's authority. They specifically state in that rule, the district judge may place conditions on the use, dissemination, or publication of the record of proceedings of the grand jury. So all this stuff we're talking about are within the control of the district judge. And so these delays, if they're caused by the district judge's orders, I'm sure that district judge will understand that there has to be a stay in order to protect the rights of the individual.
Right. Mr. Kohberger's request to stay proceedings until the grand jury record is prepared and he has adequate time to contest the indictment should be granted. The remedies allowed in Idaho Code 213.3 are the exclusive means by which a person accused of a crime may challenge a grand jury on the ground that the jury was not selected in conformity with this chapter. A stay of the proceedings is appropriate. It wouldn't surprise me if the state did not even agree to a stay, right? Because the state doesn't care if this trial goes to trial within 6 months.
Oh, absolutely. I think the state's going to agree to it.
Right. Yeah.
But I think they're going to, I think what they're going to say is, we're agreeing to it, but we may need some time too, after the defense files some motions. So maybe that should be stayed. So there may be a kind of an exchange here of stay of the speedy trial time.
I agree. And I think that the judge, at the very least, even if they do I'll show you some and you can ask for more later, that protects yourself by allowing that stay. And I actually think a stay is something everybody could benefit from in this case, because if I'm Brian Kohberger, I probably want to try to move this trial as quickly as possible, but I think it's impossible to have this trial done in October. So I think a stay could also help, because it's not like if they stay the case to deal with this, you can't work on anything else. You can continue to work on the actual case while the case is stayed, and continue to prepare and go through evidence and things like that. So a stay may help both sides really at the end of the day.
Yeah. And I think we've all heard what a burden this is placing on the public defender system in Idaho, because they don't have a lot of public defenders. And so a lot of resources are being used in this one trial that's taking away from all the other work they do.
So before we ask the final question, a Rule 48 motion to dismiss a grand jury indictment, it is filed to Judge, and he makes the decision whether or not to throw it out, right? The district court judge in this case. So then if he throws it out, what happens next?
Well, odds are it's going to get, my guess is either it's going to get appealed or they're just going to go back, correct the mistakes, and re-indict him with another grand jury. It's an easy fix.
Yeah, it is not, the double jeopardy rule does not apply. They'll just redo it, right? So even if he wins this one, he's probably going to lose the next one, unless, of course, there is a real piece of exculpatory evidence that, eventually just gets the case to go away altogether. I would be surprised if something like that happened. Number two, we have some questions started. I'm going to have to get to those. Do you think the judge will give the defense everything they want, or do you think they will do the slow play deal?
I do not think that initially he'll give them everything they want. I think they're going to have to show some reason for those items that are outside of what I believe the rule says. And or they're going to ask the judge to do an in-camera inspection of those things to see whether or not they're relevant for the defense and then give them the defense. But the initial order is not going to give them everything they want.
I agree with that. Initially, I don't think they're going to give everything they want, but at the end of the day, I do think the judge is going to give the defense everything they're asking for in this grand jury proceeding. I really do. I think if the defense can even make a somewhat plausible argument that they need something, that the judge is going to give it to them. Okay, Sleuthy made a good point here. October trial will be 10 months to prepare for trial within the speedy trial time, as opposed to only 6 months because there was such a delay in the indictment. I agree. Still not enough time. Still not enough time in this case with this much evidence and this much publicity. I think more time is needed. What do you think?
Oh, absolutely. This is a highly complex case. Multiple jurisdictions are involved, different states. The volume of evidence is going to be huge.
CH, I'm glad we already got this one answered. What happens if the indictment gets thrown out? Alicia, is it possible that the defense knows if they make it to trial, they have no chance, so they're trying to avoid it at all costs? It seems if they had real exculpatory evidence, they would reveal it. So what do you think? If you does this indicate to you that they're fighting the indictment because they think they have no chance at trial?
No, this indicates to me that they're fighting everything, every step of the way, 100%. That it's scorched earth all the way because they're defending someone for his life. And yeah, you don't slow up at any stage of the proceeding.
Yeah. No, I think that that's correct. CH, if the jury doesn't know the evidence exists, how can they ask for it?
Well,
it's kind of like, right. That's a really good question, but it's kind of like if they say, oh, we have all this cell phone data and his cell phone turned off at this point. They could say, do you have other cell phone data that shows he normally turned off his cell phone for 4 months? Or do you have where his car was driving on every other Saturday? Did he always drive a certain spot They can ask questions like that to see if the state has more evidence like that.
But again, I think that everybody should understand that the grand jurors don't necessarily get very involved in the minutia of presenting evidence.
Right.
They normally just listen to what the prosecutor presents.
Love versus money is if the stay is granted, does it also pause the time for the prosecution to bring the death penalty charges? I believe the answer is yes to that. I think it tolls all. I think it tolls all timing in the case because we are dealing. And I am not positive about this answer. I'll ask my dad if you know it, but
I don't know.
Yeah, I believe it would make sense though that it pauses everything because we are dealing with this very separate issue. Once we handle that, then we'll get back on track for the case. I believe that is the case. Patrick. What's up, Peter, George, and the Lawyer You Know fam? Glad to catch you live today. I've missed y'all. We've missed you too, Patrick. Glad you're here. Is it unusual to challenge the indictment?
Not in a murder case.
Yeah.
In first-degree murder cases, you always challenge the indictment because, again, if you don't challenge it, you've waived it, and you don't want to waive anything in a first-degree murder case. You challenge everything.
John O'Rourke, with the indictment from the state with a grand jury, the state must have a slam dunk case, correct? I'll let you answer this first, and then I have a funny answer.
No. Grand jurors, it's easy to convince a grand jury to give an indictment. You only have to prepare their bare bones case. So, it has nothing to do with how strong the case is.
So I would like to know what the percentage of slam dunks are that miss, because I think that the answer would be yes if we're going off real slam dunks, because people do miss slam dunks, but they probably make them about 90% of the time. And I'd be willing to bet that 90% of murder grand jury indictments that happen in Idaho or in federal court end up with convictions. But that was just kind of a snarky answer when I'm done.
I think it might be more than 90%.
Exactly. That's well, you don't make 100% of slam dunks. So there are slam dunks that miss too. I'm just joking with a basketball analogy there with an answer to John. Leah, I feel dumb, but if the evidence is certain if the defense is certain they have exculpatory evidence, why not present it now? Are they required to present it at a certain time? Well, there is a non-dissemination order. So, they can't just be throwing evidence or leaking evidence out there. They're not supposed to do that. But there are certain times, right, that you bring up the exculpatory evidence. You're not trying the case in the public court of public opinion, right? So there's only so many times you can bring up exculpatory evidence.
The state has a right to know what you're going to present at trial. And so at some point, they're going to be required to tell the state.
Tom, happy Father's Day to both of you. Big George, you have a wonderful family. I have to run. Take care all. Thank you, Tom.
Thank
and
you.
Happy Father's Day to you as well. Tom has reached out to me on Twitter, so I know that he is a father. Happy Father's Day, Tom. Midwest girl. If the defense has evidence he's innocent, why isn't BK out of jail right now? I understand why some families put it out there that they have a right to sue. Good for them. So go ahead, explain how a defense attorney or even a defendant can believe you have exculpatory evidence, but yet somehow you're still in jail.
Well, first off, exculpatory evidence doesn't mean you're going to convince the prosecutor that it's exculpatory.
Exactly.
Or a judge until you go to trial and you convince a jury, because that's the only level playing field is the trial. Otherwise, it's all stacked against you. The prosecutor controls everything. The grand jury, only the prosecutor's in there. So, everything is in the prosecutor's hands right now. Someday there's a level playing field, and that's the day to present your exculpatory evidence.
Right. When you have an unbiased, or you have 12 unbiased people sitting there, not a judge, not a prosecutor, not a law enforcement officer that you've been trying to tell this the entire time, not even the media, right? Because sometimes you can't convince the media. We know how the media is looking at this case, but you have 12 people that are supposed to not have any knowledge really about this case or have prejudged this case. You present what you believe is exculpatory to them at that point, and then it could absolutely be exculpatory and you could win that case. But that doesn't mean that everybody at this point believes it's exculpatory, or you wouldn't be sitting in prison. Nahlis, with this case taking forever, how do they select a jury who hasn't heard of it? It's funny. People already think this case is taking forever compared to other cases. It's moving rather quickly. But I just real quick, Dad, because we're already 2 minutes late.
Well, Peter, you covered trial after trial that's got publicity like this, and they managed to find a jury somehow. So who knows?
The first case we ever tried together in federal court, you did jury selection, one juror at a time. And sometimes in very high profile cases that, could be capital cases or life cases or whatever, sometimes that's how you have to do it. And when the lawyers have an opportunity to sit there one-on-one with individual jurors, that's sometimes the best way. Sleuthy, was a grand jury impaneled specifically for this case? I don't know that answer. Do you know that answer?
I don't. Okay. I don't. But
they don't have to
be. It may be because, again, in that jurisdiction, they don't have grand juries sitting all the time.
Right.
So they may have impaneled it just for this case.
It would make sense, but they don't have to be. Yeah. So I don't know. All right. We have to run. Lexix, thank you for the super sticker. Dad, thank you for joining me. Turn on whatever you got to turn on to be redirected, and we'll get to the hearing that the Kohberger media trying to challenge the non-dissemination order. I appreciate you guys. If you just stick through the whole time, it might run right into my YNW Melly trial breakdown. So I will see you in a couple hours. Thank you, Dad, so much again for coming on. This was actually a really good one. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.